So you see the business that I have been dealing with owes my business $100,000 based on an agreement.
Okay, so we will sue that person for $100,000.
I guess so, but I am not sure if I will win as it is only a verbal contract.
Well, if you say they owe the money, then surely we can collect it. Please put $10,000 into my trust account and I will sue them for you.
Okay.
Welcome to Streten Mason's Lawyers. How can I help you today?
Well, a client of my business owes me $100,000 based on a verbal contract that we had.
Great, well, let's have a look at your issue and see what solution we can come up with. What I want to do is introduce you to our 7-steps process to ascertain if it is worthwhile purchasing the debt from this person. How does this sound?
That sounds different.
So the first step is to ascertain your legal state. Please tell me all of the circumstances that gave rise to the debt being incurred.
Well, I agreed to supply a boat to this customer for a price of $80,000. He agreed to this price and we shook hands.
But I thought you said that the claim was for $100,000.
Well, that is the thing. He asked me to do some extras. I didn't tell him that there would be an additional cost, but I supplied additional items for the inside of a boat. You know, a TV and a stereo system.
That cost $20,000.
Well, no, the TV was only $4,000 and the stereo $1,000, but then I had to install them. He seemed like he had lots of money, so I thought that in total additional fee of $20,000.
Okay, so did he ever agree to pay the amount for the extra items?
Well, no, I just gave him the bill for $100,000 and now he is saying that he is not going to pay it. He has the boat and I have not been paid.
Okay, well, there are some issues that will require some consideration. So tell me, what do you actually want from this guy? What is your goal out of this?
Well, truth be told, I would happily take the $80,000 plus my actual costs on the other items of $5,000, so $85,000.
Okay, if you are happy with that, then that is what we will go after.
Well, I know I should have told my customer the cost up front, and because I did not, that has probably led to all of this confusion.
Great, now that I know where you are and where you want to get to, we will now analyze how you are going to get from your legal state to your goal.
Okay, sounds great.
I have to say that I am glad that you did not want to pursue that extra money. It would be difficult to recover as you did not disclose the fees.
But lawyers don't always disclose their fees to their clients.
I know it is frustrating that happens in any industry. To be able to charge a fee, you need to be able to justify that there is an agreement between the parties for the fee to be payable. In other words, you need to either tell the customer what the fee is or a method of calculation of the fee. If you do not, then it is difficult to say that there is a claim for anything more than the actual money that you outlaid. That is called a quantum merit claim.
That makes sense. How can someone owe me money if they did not know it was owing?
Now it is time to cross-correlate our findings to make a decision on where to go.
This is great. I understand exactly where I'm at.
As you can probably appreciate, it is unlikely that you are going to be able to charge any additional fee for this work, as you have done work, but you do not have a valid claim for the extra money. As I said, you can make a claim for the actual costs that you have incurred, but due to the fact that there is no agreement on the balance, I do not think that you can claim that money.
I understand that I am not entitled to that extra money. If only I had an agreement with him for that.
Yes, it is true, but let's focus on what we are going to do to fix this, and then we can consider what processes to put into place to ensure that it does not happen again. It is now necessary for us to determine exactly what you should do. Have you spoken to the client and told him that you just want the $85,000?
No, I didn't want him to know that I had only paid that small amount of money for those items. But I can see that he would probably know what they cost. They are not hard to figure out.
No, they are not. I see that you have a number of options. Firstly, you could contact the client directly and say that you do not want to go to court and see whether he will pay you that amount. Secondly, you could just sue him for the money.
Suing seems a bit premature at this stage. Perhaps I should go and speak to my client and see if he can pay the money.
Excellent. I think you will find that if you discuss this with your client properly and succinctly, explaining where the figures came from, that he will understand and will pay that amount. Going to court will cost you a lot of money, and if you can resolve your dispute before commencing proceedings, then that is the best outcome for you.
Yes, it is.
I will prepare an advice for you confirming this position. I will also like to point out a few simple processes that you should implement to ensure that this does not happen again.
Great prevention is better than a cure.
That is right. I will include this in my advice report, but you need to ensure that you have a written agreement between the parties for all works, and that if there are any variations, that you do that in writing with the other parties. A simple email can suffice, but you just need to ensure that the systems are in place. Now let's talk about the fixed fees.
Thank you so much. I rang my client and discussed it with him.
And what was his response?
He said that he was happy to pay that amount and came around and gave me a bank check. You have saved me thousands of dollars and all because we stood back and went through the 7-step plan.
Excellent. Now that you have that immediate problem sorted, let's work on ensuring that this never happens again.
Great, let's get started.